I lost my entire inheritance, $1.8 million in 17 minutes, sitting in a courtroom where my own family stood against me, and my brother wouldn't even look me in the eye while the judge read the decision that erased me from everything we had built together. 6 years later, I walked back into that same courtroom, wearing a suit with my name on the case file, standing at the front instead of the defense table. And when the judge asked who would be leading the argument, I said, "I'm the one representing the opposing side." And that was the moment my family realized they weren't about to watch me lose again. They were about to watch me take everything back, one fact at a time. I grew up in a family where success was always visible, always measured, and never evenly shared. And as the youngest daughter, I learned early that my role was to support quietly rather than stand in the spotlight, even when I had earned the right to be there. My name is Olivia Hayes, and while my family owned a growing chain of restaurants across Dallas, I was the one who chose law, not because anyone encouraged me to, but because I needed something that belonged to me, something no one else in my family could take credit for without understanding the work behind it. My father respected results, my mother valued appearances, and my older brother Ryan fit perfectly into both worlds, confident, charismatic, and always exactly where people expected him to be, especially when it came time to represent the family business. While Ryan was being introduced as the future of the company at networking events and investor dinners, I was the one sitting behind a laptop late at night, reviewing contracts, adjusting clauses, and making sure every expansion deal held together under legal pressure, even though no one outside our office knew I existed in that process. I wrote the agreements that allowed us to open 3 new locations in less than a year, negotiated terms that protected us from losing control to outside investors, and flagged risks that could have cost us everything if they were ignored. But when the final documents were printed, reviewed, and signed, it was always Ryan's name at the bottom, bold and visible, while mine never appeared anywhere. At first, I told myself it made sense, that he was the face of the company and I was still just a student building experience, and I convinced myself that recognition would come later. Once I had officially graduated and proven myself in a way that no one could dismiss, but the pattern never changed. And neither did the quiet expectation that I should be satisfied with contributing without being acknowledged. There was one moment that should have felt different when we closed our largest expansion deal with a group of investors from Houston, and I remember watching Ryan shake hands across the table while my father stood beside him, proud and fully engaged. And for a second, I thought someone might mention the work that had made that deal possible. But instead, my father simply said, "Ryan handled this well." And the conversation moved on as if that was the complete truth. I didn't argue, and I didn't correct him. One, because by then I understood something that had never been said out loud but was always present in every decision they made, and it was that being right didn't matter as much as being seen. And in our family, I was never the one they chose to see. The deal that changed everything started like any other expansion opportunity, a polished proposal from a private investment group offering fast capital and aggressive growth, and at first glance, it looked like the kind of move my family had been waiting for, the kind that would push our restaurant chain into a completely different level of visibility. But something about it felt off the moment I began reviewing the contract in detail. And the more I read, the clearer it became that buried inside the language was a control clause that would allow the investors to take operational authority if certain revenue targets were not met within 18 months, which in our industry was not just risky. It was almost guaranteed to happen under pressure. I brought it to the table carefully, not as an accusation but as a concern, walking them through the clause line by line, explaining exactly how the control could shift and how difficult it would be to reverse once it did. And I expected resistance, but I did not expect dismissal. Not like that. Not so immediate and absolute, as if I had interrupted something more important than the truth itself. Ryan leaned back in his chair, barely glancing at the section I had flagged, and said I was overcomplicating things. That deals at this level always looked intimidating on paper, and my father followed with a tone I had heard before, calm but final, telling me I was seeing problems because I wanted to find them. Then came the part that stayed with me, the part that made it clear this was no longer about the contract, because my mother looked at me and said, "You need to stop trying to interfere with your brother's work just because you're not the one leading this." And in that moment, the entire conversation shifted away from facts and into something else, something personal, something I had no intention of turning it into, but I was already losing control of it. I tried once more to bring it back to the clause, to the actual risk, but Ryan closed the folder, stood up, and said, "We're not killing this deal because you're nervous." And that was the end of it. Not because the issue was resolved, but because they had decided it didn't matter. But that wasn't the worst part. Because a week later, when the final version of the contract was circulated for signatures, I opened the document expecting to see the same clause I had flagged, maybe softened, maybe adjusted. But instead, I saw something I didn't recognize at all, a version of the agreement that now included revisions I had never written, language that weakened our position even further. And at the bottom of the document, under "prepared by," was my name. I remember staring at it for a long time, trying to understand how it got there, how my work had been replaced and reassigned to me at the same time. And when I confronted Ryan, he didn't deny it. He simply said it was easier this way, that it kept the process clean, that no one needed confusion about who was responsible for what. The consequences came faster than I thought possible, because when the investors exercised parts of the agreement that shifted leverage away from us, the blame didn't move through the company. It landed directly on me, exactly where the document said it should, and within weeks, I was sitting in a courtroom, listening as my own family's legal team argued that I had been negligent, that I had drafted a flawed contract that put the entire business at risk, and that I should be held accountable for the financial damage it caused. I tried to speak, to explain, to point out the inconsistencies, but everything I said sounded like defense against evidence that already had my name attached to it. And evidence, in that room, carried more weight than anything I could say. The ruling took less than 20 minutes, and when it was over, I was no longer just the daughter who had been overlooked. I was the one officially responsible for the loss, the one removed from any future claim to the business, the one who had, in the eyes of the court and my own family, cost them everything. And as I walked out of that building, past people who had once called me part of something, I realized the humiliation wasn't just private anymore. It had been made public, documented, and sealed in a way that no explanation could undo. After the ruling, I thought the damage would stay inside the courtroom, contained within the documents and the people who had been there to witness it. But I was wrong, because within days, my name began to circulate in a way that had nothing to do with context or truth, and everything to do with reputation. Firms I had applied to before the case suddenly stopped responding. Interviews that had seemed promising were quietly canceled, and the few contacts I had in the legal field either went silent or offered vague explanations that never quite addressed what had changed, even though we all knew exactly what it was. I started to understand that in a profession built on credibility, one public loss, especially one framed the way mine had been, could close doors before you even reached them. I kept applying anyway, sending out resumes, following up, trying to rebuild some kind of footing, But each rejection felt less like a decision based on merit and more like a confirmation that my name now carried a warning attached to it. Something unspoken but clearly understood by anyone who saw it. Even the people who had once studied with me began to keep their distance, not out of cruelty, but out of caution, as if being associated with me might complicate their own path forward, and conversations that used to be easy became short, polite, and carefully limited. It wasn't just that I was struggling to find work. It was that I was being quietly removed from the space I had spent years preparing to enter. What I didn't realize at first was that this wasn't happening on its own. It wasn't just the natural consequence of a bad case, because the story being told about me had a consistency to it that didn't come from assumption, it came from repetition. And eventually, I heard it directly from someone who didn't think they were telling me anything new. They said my case had been brought up during a small industry event, not as a warning about legal risk, but as an example of what happens when someone oversteps their role. And the way it was framed made it clear that the narrative had been shaped long before it reached that room. That was when I understood the final twist of it all. Because this wasn't just about losing in court, it was about control over the story that followed, and my family, the same people who had stood across from me in that courtroom, had taken that case and turned it into a lesson for others, repeating it in conversations, in meetings, in places where decisions were made about who could be trusted and who couldn't, using my name as proof of a point that had nothing to do with the truth and everything to do with reinforcing their version of it. And just like that, the thing I had lost wasn't only money or position. It was the ability to be seen without that story being told before I ever had the chance to speak for myself. I stayed in Dallas for 3 more weeks after the case, long enough to convince myself that there might still be a way to fix it, that if I just kept trying, kept explaining, something would shift. But nothing did, and every door I approached seemed to close before I even reached it. My apartment felt smaller each day, not because of the space, but because of what it represented. A place I could no longer afford, in a city that no longer had a place for me, and eventually, the silence became louder than any rejection I had received. I started packing without telling anyone, folding clothes into a suitcase that felt heavier with each item, and not because of the weight, but because of the realization that I was leaving behind everything I had once believed was permanent. There was no dramatic goodbye, no confrontation, no final attempt to change anyone's mind, because by then I understood that none of it would matter. Not the documents, not the facts, not even the truth. And for the first time, I stopped trying to be heard by people who had already decided not to listen. I canceled my lease, sold what little I could, and withdrew the last of my savings. Which wasn't much, just enough to get me out of the city and into something uncertain, something undefined. But at least it wasn't Dallas, and it wasn't tied to a version of me that no longer existed. The night before I left, I sat on the floor of my empty apartment, when surrounded by boxes I didn't need and things I couldn't take with me, and I let myself feel it. Not just the loss of money or status, but the deeper kind of loss, the kind that comes when the people who are supposed to stand beside you instead become the reason you have to start over. And for a moment, I wondered if I should fight it, if I should file an appeal, reopen the case, try to reclaim what had been taken from me in a room where I hadn't been given a real chance to defend myself. But that was the twist I didn't expect. The decision that didn't come from anger but from clarity, because I realized that going back into that system, into that narrative, would only keep me tied to it. And I didn't want to win that way anymore. Not if it meant staying in a story that had already defined me as something I wasn't. So I didn't appeal. I didn't call a lawyer, and I didn't try to correct the record. Instead, I did something much quieter and, in its own way, much more final, I disappeared, not in a dramatic sense, but in a deliberate one, leaving behind the version of Olivia Hayes that everyone in Dallas thought they knew, and stepping into something that had no expectations attached to it at all. The city I moved to didn't matter as much as what it offered, which was distance, anonymity, and a chance to exist without the weight of my last name following me into every conversation. And for a while, that was enough, even if it meant starting at the very bottom of a profession I had once expected to enter at a much higher level. I found a position as a legal assistant in a small office that handled minor contract disputes and paperwork. Most firms didn't consider worth their time, and the pay barely covered rent for a narrow room in a shared apartment where the walls were thin and the furniture didn't quite match. But it was a place to sleep, a place to think, and more importantly, a place where no one knew my past. I worked quietly, taking notes, reviewing documents, doing everything that was asked of me without drawing attention, because attention had never worked in my favor before, and over time, I started to see patterns again, small inconsistencies in contracts, overlooked clauses, details that didn't belong where they were, and I corrected them when I could, carefully, without making it obvious. But even that small progress didn't change the reality of my situation, which was that I was still trying to re-enter a field that had already decided who I was. I applied to firms whenever I found an opening, adjusting my resume, rewriting my cover letters, trying to present myself in a way that would be evaluated on its own merit. But rejection after rejection came back. Some polite, some brief, and some not at all, and each one carried the same quiet message that I wasn't being considered. Not really. Then came the first real break, or what I thought was one, when a mid-level attorney offered me a chance to assist on a larger case, promising exposure, experience, and the kind of work that could finally move me forward, and I accepted without hesitation, staying late, taking on more responsibility, doing work that went far beyond the role I was officially hired for, believing that this was the moment things would begin to shift. Weeks turned into months, and the case progressed, but the promises didn't. And when I finally asked about compensation, about the terms we had discussed at the beginning, the response was simple and controlled, that I had misunderstood, that this had always been an informal arrangement, and that if I was unhappy, I was free to leave. I left, not because I wanted to, but because I had no choice, and the next position I found didn't last long either, cut short by budget issues that had nothing to do with my performance, but everything to do with how easily I could be replaced, and suddenly I was back where I had started. Only this time with less savings, fewer options, and in a growing sense that the ground beneath me wasn't stable at all. There were weeks when I calculated every expense down to the smallest detail, deciding what could be delayed, what could be skipped, and whether I would be able to cover rent at the end of the month. And for the first time, the idea of failure wasn't abstract anymore. It was immediate, practical, and impossible to ignore. I thought about going back, about returning to Dallas, about facing everything I had left behind just to have something solid again. But every time the thought came up, it was followed by the same realization that nothing there had changed, and that going back wouldn't solve anything. It would only confirm what they already believed about me. So I stayed, even when staying meant uncertainty. And I kept applying, even when each application felt less hopeful than the last, until I reached a point where there was only one firm left that had shown even a small amount of interest, a final interview that I prepared for with a level of focus that bordered on desperation, because I knew what it represented. I think everything is about to end, I remember thinking as I walked into that office, not because I lacked confidence in my ability, but because I had run out of places to go if this didn't work. And when the interview was over, the conversation polite, but distant, I could already see the outcome before it was confirmed. The rejection came 2 days later, brief and carefully worded, thanking me for my time and wishing me the best. And for a moment, I accepted it as just another closed door, another step in a pattern I had come to expect. But the twist came quietly, in a conversation I wasn't meant to overhear, when someone in the office mentioned my name in a tone that wasn't curious, but familiar, referencing the case I had tried to leave behind. And it was then that I understood what had been happening all along, that this wasn't just a series of independent decisions. It was something more coordinated, more persistent, a kind of unspoken agreement within the field that certain names carried risks not worth taking, and mine had become one of them, not officially, not documented anywhere I could challenge, but real enough to follow me from one opportunity to the next. I didn't notice him at first, not in the way people usually notice someone important, because he didn't introduce himself, didn't interrupt, and didn't try to position himself as anything other than another person moving through the same space I was. But later, I would understand that he had been watching long before I realized it, not in a personal way, but in a professional one, the kind that pays attention to details others overlook. His name was Mr. Calder, a senior attorney who had spent decades in litigation, someone whose reputation didn't need to be announced because it followed him quietly, the same way mine had once followed me for the wrong reasons. The first time he spoke to me was after I had submitted a routine document review. Something small, something I didn't expect anyone to read closely, but he called me into his office and asked me a question that no one else had ever asked. Which was why I had flagged a clause that technically wasn't incorrect, but felt structurally unstable, and I explained it the only way I knew how, not with confidence, but with precision, walking through the language, the implications, and the potential outcomes if it were challenged under pressure. He didn't respond immediately, just listened, then nodded once and said, "That's not something people usually see at your level." And for a moment, I didn't know how to answer because I wasn't used to being evaluated on what I actually understood. A few days later, he asked me to bring in my previous case, the one I never mentioned unless I had to, and I hesitated, not because I didn't want him to see it, but because I already knew what it looked like on paper. And I had spent months trying to move past that version of myself. But he insisted, not with pressure, but with certainty. And when I handed him the file, I expected a quick review, a confirmation of what everyone else already believed. Instead, he spent nearly an hour going through it, page by page, not skipping anything, not rushing, and when he finally looked up, there was something different in his expression, something closer to recognition than judgment. He pointed to a section in the contract, one I knew well, one I had tried to explain years earlier, and asked why the language had shifted so abruptly between drafts, and I told him the truth, that it hadn't been my revision, that it had appeared in the final version without my input, and for the first time since the case had ended. Someone didn't dismiss that explanation as an excuse. He leaned back in his chair and said, almost to himself, "This wasn't negligence," and the words landed in a way I hadn't expected, not as validation, but as a possibility I hadn't allowed myself to consider anymore. That was the moment everything changed, not outwardly, not in a way anyone else could see, but in the way he began to involve me in his work, starting with small assignments that required careful reading, then gradually moving into more complex cases where the outcome depended on finding what wasn't obvious. And I realized that the one thing I had carried with me, even through everything I had lost, was the ability to see the weak point in something that appeared solid, to read between the lines in a way that went deeper than surface logic. He didn't promise anything, didn't say he would fix what had happened to me, but he gave me something much more important, which was a chance to use that skill again, this time in a place where it mattered, and where someone was actually paying attention. Working under Mr. Calder was not a sudden transformation. It was a process built on repetition, discipline, and the kind of quiet consistency that doesn't attract attention but changes everything over time. And in the beginning, my role was still limited, reviewing documents, preparing summaries, and sitting in on meetings where I spoke only when asked. But each assignment came with an expectation that I would see something others might miss, and gradually, that expectation became a standard I held for myself. The cases we handled were not high profile, at least not at first. Small disputes, contract disagreements, issues that larger firms considered routine, but within those cases, I found opportunities to apply the same depth of analysis that had once been dismissed, identifying inconsistencies, tightening arguments, and helping build strategies that held up under pressure. And one by one, those cases began to turn in our favor. There were no dramatic celebrations, no public recognition, just quiet acknowledgments in the form of increased responsibility, a longer list of tasks, and eventually, a seat at the table where decisions were made. And for the first time in years, I was not being overlooked. Not because I demanded attention, but because the work itself made it impossible to ignore. I passed my licensing exam on the second attempt. Not easily, but thoroughly. And when the official confirmation arrived, it didn't feel like a victory anyone else could measure. It felt like something I had rebuilt from the ground up, without shortcuts, without validation, and without anyone else's approval. From there, the progression was steady, moving from support roles into active litigation, handling more complex cases, standing in court not as an observer but as a representative, and with each outcome, each successful argument, I became more certain of what I was capable of, not in theory, but in practice. Over time, I developed a focus, a specialization in litigation that required precision and patience, the ability to break down arguments, anticipate responses, and find the point where everything could shift. And it was in that process that something unexpected began to happen, something that had nothing to do with the cases I was currently handling and everything to do with the one I had left behind. Without making it obvious, without telling anyone what I was doing, I started to revisit the documents from my past. Not all at once, but piece by piece, requesting access where I could, reconstructing what I had lost through fragments and records that still existed in different places. And as I went through them again, this time with experience and distance, I began to see patterns that I hadn't fully understood before. The revisions that had once been attributed to me did not align with the earlier drafts in a way that made sense. The language shifts were too abrupt, the structural changes too deliberate, and the more I analyzed them, the clearer it became that this wasn't a mistake. It was a modification with intent, a series of decisions that had altered the contract in ways that directly led to the outcome I had been blamed for. I didn't announce this discovery, didn't bring it to Mr. Calder immediately, because I needed to be certain, not just of what I believed, but of what I could prove. And for the first time since everything had fallen apart, I wasn't looking at my past as something to move beyond. I was looking at it as something that might finally be understood correctly, not through explanation, but through evidence. The case that brought everything back into alignment didn't arrive as a coincidence. It came through the firm like any other high-stakes litigation, a complex commercial dispute involving a regional restaurant group facing a lawsuit from one of its primary investment partners. And at first, It was just another file assigned for review, another set of documents to analyze, another situation that required careful strategy and precise execution. The scale was larger than most of what I had handled before, the potential loss significant enough to threaten the entire business structure. And as I began reading through the materials, I recognized the patterns immediately, the same type of contractual weaknesses, the same structural vulnerabilities I had once tried to explain years ago, only now they were fully exposed under legal pressure. Then I saw the name, not in a dramatic way, not as a sudden reveal, but as a line in a document that connected everything I had worked to separate. And for a moment, I stopped reading. Not because I didn't understand what I was looking at, but because I understood it too clearly. It was my family's company, the same chain that had expanded rapidly, the same business I had once helped build from behind the scenes. Now facing a lawsuit that could strip away control, ownership, and everything they had worked to protect, and the details of the case mirrored the exact risk I had warned them about, the one they had dismissed, the one that had ultimately been used against me. I didn't say anything at first, not to Mr. Calder, not to anyone in the firm, because the connection wasn't relevant to the assignment as it stood. And more importantly, I needed to be sure that my involvement would be based on what I could contribute, not where I came from. So I continued the review, building out the legal framework, identifying the leverage points, outlining the arguments that could define the outcome of the case. It was only later, during a strategy meeting, that Mr. Calder asked if I would be comfortable taking a more active role, leading specific aspects of the litigation, and I agreed without hesitation, not because of the history attached to it, but because I was prepared for the work itself. The twist, when it came, wasn't announced. It wasn't framed as anything unusual. It was simply understood within the structure of the case that our firm would be representing the opposing side, the party seeking enforcement of the contract, the one pushing for control under the terms that had been agreed to years earlier. And as the responsibilities were assigned, my role became clear, not just as support, but as one of the attorneys responsible for presenting key arguments in court. By then, the connection was no longer abstract, it was direct, and it carried a weight that had nothing to do with emotion and everything to do with consequence. I knew what it meant for them, what was at stake, what they were about to face. And I knew something else just as clearly, something they had no way of anticipating, because as the case moved forward and the hearing date was set, there was one detail that remained entirely outside their awareness, one fact that would only become visible at the moment it mattered most, and it was this, that when they walked into that courtroom to defend everything they had left, they would not be facing a stranger. They would be facing me. And they had no idea that I would be the one standing on the other side, representing the case against them. The courtroom felt familiar in a way I hadn't expected, not because of the space itself, but because of what it represented. A place where decisions became permanent and narratives were turned into records. And as I took my seat at the counsel table, I kept my focus on the documents in front of me, not on the people across the room, not on the faces I already knew would be there. My family arrived a few minutes later, moving with the same confidence I remembered, though it was thinner now, less certain, shaped by the pressure of a case they could not easily control, and they took their seats without looking in my direction, because at that moment, there was no reason for them to. When the judge entered, the room settled into silence, the kind that signals the beginning of something that cannot be undone, and the formalities moved quickly. Names were stated, positions clarified, and then came the moment that shifted everything, the one that didn't need emphasis because of how simple it sounded. The judge looked down at the file and said, "Lead counsel, please proceed." And for a fraction of a second, nothing happened, because no one on their side expected what came next. I stood. There was a pause. Not long, but complete. The kind that interrupts thought before it has time to adjust. And as I stepped forward, I saw the recognition happen in stages. First confusion, then disbelief, and finally the realization that could not be redirected or denied. My father's expression tightened, as if he were trying to reconcile two versions of reality at once. My mother's hand moved slightly, as if she needed something to hold on to, and Ryan didn't react at all at first. He just stared, the way people do when they are waiting for something to make sense, and it doesn't. "I represent the plaintiff in this matter," I said, my voice steady, measured exactly the way it needed to be. And the words didn't carry emotion. They didn't need to, because the position itself was enough. The silence that followed wasn't empty. It was filled with everything that had been left unsaid for years, compressed into a single moment where none of it could be avoided anymore. When I began presenting the case, I didn't rush, I didn't raise my voice, and I didn't reference the past in any personal way. I focused entirely on the structure of the contract, the clauses that defined control, the conditions that had been agreed to, and the exact points where the original language had been altered. And as I moved through the argument, I introduced the earlier drafts, the documented revisions, and the inconsistencies that connected them, building a line of reasoning that didn't depend on interpretation, but on evidence. I pointed to the section that had triggered everything years before, the clause that allowed a shift in operational authority, and then I showed how the language had been modified in the final version, not gradually, not through standard negotiation, but in a way that bypassed the continuity of the document. And I placed both versions side by side, highlighting the differences, not as accusations, but as facts that could be verified. I explained how those changes directly led to the current position of the company, how the risk I had identified had not only been real, but inevitable once the contract was executed under those terms, and how the attribution of that language had been assigned in a way that did not align with the documented drafting process. There were no interruptions, no objections strong enough to break the flow, because each point was supported, each statement anchored in something that could be traced and confirmed, and by the time I finished, the room was no longer reacting to me as a person. It was responding to the structure of the case itself. The judge reviewed the materials, asked a few precise questions, and then made a statement that carried more weight than anything I could have said on my own, noting that the evidence presented established a clear inconsistency between the original drafts and the final executed document, and that the argument regarding responsibility deserved serious consideration under the law. In that moment, the validation didn't come from emotion or recognition. It came from authority, from a process that didn't depend on belief, but on proof, and for the first time in 6 years. In what I had tried to explain was no longer dismissed as interpretation, it was acknowledged as fact, not privately, not quietly, but in a courtroom where every word entered the record and stayed there. The shift didn't happen all at once. It moved through the room in a way that was almost quiet, but impossible to ignore. Because once the structure of the case had been laid out clearly, there was nothing left for them to hold on to except the version of the story they had relied on for years, and that version no longer matched what was in front of them. Ryan was the first to react, not with a clear response, but with hesitation, the kind that comes when the argument you were prepared to make no longer applies, and as his attorney tried to redirect, to reframe the issue as a matter of interpretation, Ryan interrupted me, his voice sharper than it needed to be, pushing back against points that were no longer being debated but demonstrated. He tried to regain control, to shift the focus away from the documents and back toward intent, toward the idea that the outcome had been influenced by factors outside the contract itself. But the more he spoke, the more fragmented it became, because every statement he made was met with a reference, a page, a clause, something that anchored the discussion back to evidence, and gradually, the confidence he had entered with began to fade, replaced by something less stable, something reactive rather than controlled. The judge intervened more than once, not to challenge him personally, but to keep the argument within the boundaries of what could be supported. And each interruption made it harder for him to continue in the way he had planned. Across the table, my parents didn't speak at all, and that silence carried more weight than anything they could have said, because for the first time, they were not being asked to choose between two perspectives. They were being shown a sequence of facts that didn't require interpretation, and I could see the recognition settle in slowly, not as a sudden realization, but as a series of small shifts, the way someone adjusts when something they have believed for a long time begins to move out of place. My father's posture changed, his shoulders lowering slightly as if the certainty he had held onto was no longer there to support him, and my mother's attention moved from Ryan to the documents, her eyes tracing the pages in a way that suggested she was seeing them differently now. The narrative they had relied on, the one that had defined me in their minds and in the eyes of others, didn't collapse with a single moment. It unraveled under pressure, piece by piece until there was nothing left to reinforce it. And in that space, where explanation used to be dismissed and replaced, there was only the reality of what had been presented, clear, structured, and impossible to redirect back into something more comfortable. For Ryan, that loss of narrative was immediate and visible, the shift from control to uncertainty happening in real time. But for my parents, it was quieter, deeper, a recognition that didn't need to be spoken to be understood, because by then, the question was no longer what had happened. It was why they had chosen not to see it when they had the chance. When the proceedings paused and the room shifted from argument to outcome, there was a brief moment where everything could have gone in a different direction, where the next step might have been escalation, a push to leverage the position we had established and take the case as far as it could go, because the structure of the contract allowed for it and the advantage was clearly on our side. But that was not why I was there, and it was not what I had spent years rebuilding myself to become. I stood when it was appropriate to respond, not to extend the conflict, but to define its boundary. And when the judge looked in my direction, I spoke without raising my voice, without addressing them as family, and without referencing anything outside the case itself. Because this moment didn't need emotion, it needed clarity. "I'm not here to destroy you," I said, keeping my focus on the court, not on the people across from me, even though I could feel their attention shift in a way that was impossible to ignore. "I'm here to correct what you refused to see." The words were simple, but they carried the weight of everything that had been presented, not as a statement of power, but as a statement of purpose. And once they were said, I didn't add anything else, because there was nothing more that needed to be explained. The position I outlined was precise, grounded in the same evidence I had already introduced, proposing enforcement where it was justified, but also limiting the scope in a way that preserved the structure of the business rather than dismantling it entirely. And it was a decision that came from a place that had nothing to do with forgiveness and everything to do with control, the kind that doesn't need to be proven because it already exists. The judge acknowledged the proposal, noting its balance and the reasoning behind it, and the case moved forward from there, not as a collapse, but as a correction, a realignment based on what had been established in the record. When it was over, I didn't approach them, didn't wait for a conversation, and didn't offer anything beyond what had already been said in the only place it needed to be said, because whatever came next was no longer something I needed to manage. I gathered my files, stepped away from the table, and left the courtroom the same way I had entered, focused, steady, and separate, not out of distance for its own sake, but because the space between us had already been defined, not by what I chose to say now, but by what they had chosen not to see then. I didn't walk out of that courtroom feeling like I had won something, not in the way people usually define it, because what mattered wasn't the outcome itself. It was the fact that I no longer needed anyone in that room to agree with me in order to stand on what was true. And that shift, quiet as it was, changed everything about how I saw the past and how I moved forward from it. For years, I had tried to explain, to be heard, to correct a version of events that had never been accurate, and every attempt had been measured against belief instead of evidence, against perception instead of structure. And now, standing on the other side of that process, I understood something I hadn't fully accepted before, which was that belief is fragile, but proof is not. You don't need people to believe you. You need proof that stands without them. That idea didn't come to me all at once. It was built slowly, through every rejection, every quiet failure, every moment where I had to rely on what I knew instead of what anyone else said about me. And by the time I stood in that courtroom again, I wasn't there to change minds. I was there to present something that didn't require permission to exist. They erased me in 17 minutes, reduced everything I had done to a single narrative that fit their version of the story, and for a long time, I thought the only way forward was to undo that moment, to go back and correct it, to prove that it had been wrong from the beginning. But what I eventually realized was that I didn't need to return to that version of myself to fix it. I needed to build something stronger in the present. Something that could stand on its own, regardless of how I had been defined before. So I rebuilt, not all at once, not perfectly, but consistently, through work that no one saw at first, through cases that didn't matter to anyone except the people involved, through decisions that didn't look significant until they were repeated enough times to become something solid. And over time, that foundation became more real than anything I had lost. So I rebuilt myself, one case at a time. If you were in my position, would you have made the same choice? Would you have stepped into that courtroom and helped correct what your own family refused to see? Or would you have walked away completely and never looked back, choosing distance over resolution? And when it comes down to it, what matters more to you, justice or loyalty? Because sometimes they don't lead to the same place. And if you had to decide, would you help or would you cut it off entirely? Let me know. Yes or no?